The Second Amendment Foundation's Kostas Moros on the new DOJ suit against LA over CCW permit delays. That and more on this episode of the Weekly Reload Podcast.
No, the devil's got no hold on me.
All right, welcome, ladies and gentlemen, to another episode of the Weekly Reload Podcast. I'm your host, Stephen Gutowski. I'm also the founder of thereload.com, where you can head over and sign up for our free weekly newsletter today if you want to keep up to date with what's going on with guns in America from a sober, serious perspective that focuses on hard news and analysis over opinion and bloviating. This week, we are going to talk about, something new, something we have not seen maybe ever, or at least not for several, over a century, I guess, at this point. And that is a DOJ case going after state officials over the violation of a civil right, but in this case, the Second Amendment rights. And to do that, to have that discussion, we have with us a lawyer from the Second Amendment Foundation who is involved in litigation over this exact issue, and who may well have inspired this case from the DOJ, and that is Kostas Moros. Welcome back to the show, Kostas. Thank you so much for joining us.
Thanks, Stephen. Always a pleasure to be on.
Absolutely. And, let's start off right away on just what exactly is going on here. So, this is not something that we've seen, at least not for a very long time. I might get into what I mean by over a century there, but DOJ has filed a case against the Los Angeles Sheriff's Office, alleging that they are violating the Second Amendment rights of Los Angeles residents, including yourself. Actually, it's another thing we'll talk about. You are affected by this directly, because the county, the sheriff's department, is intentionally, as pattern and practice, essentially delaying people's applications to try and prevent them from being able to carry, despite the Supreme Court's ruling in Bruin. Is that the long and short of it? Can you give us a little more background on exactly what's happening?
That's basically it. So in LA, it takes over a year and sometimes as long as 2 years to get a permit from the Los Angeles Sheriff's Department. And this has been an ongoing issue since Bruin came down. We have sued them in a case called CRPA versus LASD, which also involves my current employer, Second Amendment Foundation, and GOA and others, over this issue. And we even won a preliminary injunction, but just as to the individual plaintiffs in that case. So since then, LA has, in fits and starts, tried to improve the situation, but all that's really happened is the wait time's gone from about 2 years to about 14 months, and the progress has been way too slow. So DOJ, shortly after the second Trump administration came in, launched a pattern and practice investigation into this issue, and now they've filed, as far as I'm aware, the first ever Second Amendment civil rights lawsuit by the federal government, at least in modern history, as you were saying.
There was Cruikshank's, I guess, since I've teased this, we might as well discuss it real quick. Cruikshank was a landmark decision in 1876, I believe, in the Reconstruction era, where that stemmed from the Colfax massacre, where a bunch of KKK members murdered over 100 Black people in the South, and the DOJ sued to enforce the laws, and part of that suit involved claims that the murderers had infringed on the victims' civil rights, including their Second Amendment rights. And that is actually, it was a landmark case in a very negative way, I think most people would say these days, but it established essentially this idea that the Bill of Rights in the federal Constitution does not apply directly to state actors or individuals, as DOJ had tried to argue in that case. And it took about a century before the law changed its mind on that and started to incorporate, once again, the Bill of Rights to state actions or individual actions, including the Second Amendment in McDonald, which didn't happen until 2010. Right. So we didn't get back around to the idea that state actors can't infringe on the Second Amendment rights of their constituents. And for
150 years?
Yeah,
Oh,
150
140 years, something like that. Yeah.
Yeah. So, and now, but so I don't know how you view Krushank. Might have been the first DOJ attempt to do something like this, but certainly appears to be the first time since then. And this is different. It's a pattern in practice, as you described. What exactly does that mean? How does that? What is a pattern in practice investigation? What is a pattern in practice suit?
Sure. So, as the name implies, they're looking to see if there's a pattern or practice of violating civil rights as opposed to a one-off issue. Is this something widespread that's happening? And it looks like the DOJ thinks so. I think in this case, it was pretty obvious. The only question, I guess, LASD, as we'll get into, might argue if there is a delay, it's not intentional. But regardless, people are objectively, as LASD has admitted in our case too, people are waiting over a year for their permits. That's the fact, whether it's intentional, whether it's because they say they don't have enough resources, it is happening. So it should be addressed, because one of the things the Supreme Court said in Bruin was, although permitting's okay, we're not going to rule out challenges to lengthy wait times or high fees when those have the effect of denying people their right to carry. So that's exactly what our lawsuit is. And I think that's exactly what this DOJ lawsuit is.
Right. And you actually were one of the people who was publicly advocating that DOJ undertake an investigation like this, right? At the beginning of the Trump administration, I remember that you were talking about how DOJ should try to do something like this. Did you hear from DOJ at all in the course of their decision to look into LA's practices?
Yeah. So during the transition period, I think it was November or December after the election, I floated, the Biden administration, the Obama administration had done these civil rights lawsuits. And why not do one for the Second Amendment? We have this, what I think is a very low hanging fruit issue. I think even a lot of people who are skeptical of the Second Amendment would agree that, 2-year wait times for a constitutional right is ridiculous. So this is an easy one, to knock out. And honestly, no one was more surprised than me, but they actually took the suggestion. I think they saw that it is indeed something they could help with, and it is an easy issue. And while we were litigating at the time, I was still with Michelle and Associates, and we got a call from DOJ basically saying they liked the idea and they wanted to talk to us about our case and what we had learned. And that's how the investigation launched from there. And it was pretty clear to us, although we couldn't be sure until this week when it happened, that this investigation would result in a federal lawsuit. So, yeah.
Yeah, and tell us a little more about your case. Obviously, you previously worked at Michelle and Associates, which is the law firm behind this similar case from the gun rights side. Now you're at the Second Amendment Foundation, who is also a party to the case. What were your claims? And then how does this new DOJ suit impact what you guys are doing?
Sure. So CRPA versus LASD is a wide-ranging case. It had high fees, non-resident carry, all this stuff, but focusing on the wait times issue. So we sued almost identically on the issues that DOJ sued. We said, we have these individual plaintiffs who have been waiting almost 2 years for a permit, and also we have the associational plaintiffs who their members are also affected. And so we pursued a preliminary injunction and we won, but the judge, unfortunately, as I said earlier, limited it to just our 2 individual plaintiffs. So they got relief. They got sped up in the process and they got their permits. So we do have a ruling from a federal court on a preliminary injunction saying basically, what she said was she refused, because it was a preliminary injunction, to draw a precise line. But she said, whatever is too long of a wait time, I don't know what that is, but clearly 2 years is too much. That was basically her ruling. 2 years is too long. So for the purposes of a preliminary injunction, that's enough. And she ordered relief. And now the case is proceeding to final judgment. There's been some settlement talks. We'll see if anything comes of that. But as of now, there's been no settlement with LASD. And I don't know if there was a settlement coming. I don't know how this changes it, this federal lawsuit. So we'll have to see what my old colleagues over there at Michelle and Associates come up with on that. But so yeah, as of now, it's proceeding to final judgment. We'll have to see what happens. We're hoping for a resolution on this issue, and we're very happy. I'm very happy, certainly, for the help from the federal government.
And what do you think the DOJ getting involved in this issue, like what could they actually accomplish that couldn't be accomplished through your lawsuit?
I mean, simply put, they can put the fear of God in all these other counties because LASD is not the only problem. I mean, they're the worst offender, but LAPD, the city of LA Police Department, they also take about 2 years to process permits. A number of counties in California, while they don't take quite that long, do take over 6 months. So, and then there's issues in New York with this. In Illinois, there's been some waiting time issues. So if this is basically a shot across the bow, I think, by the Trump administration saying, hey, we're going to try and win this here, and then we can just file the same lawsuit everywhere, And we've already seen certain counties make efforts to improve their wait times, to improve the situation. I couldn't get a response from LAPD for months about these issues back when I was at Michelle and Associates. And then once the pattern and practice investigation started, I got a letter from them out of the blue basically saying, here's what we're doing to try and resolve these issues. So, I think they are afraid of this because, CRPA, SAF, they're great, and we can try and win our lawsuits. But at the end of the day, the federal government, they know, is much more well-funded, much more well-resourced, and can make their life a lot more difficult than, a private Second Amendment association can. So.
Yeah. Now, and these pattern and practice lawsuits, which usually are about, racial discrimination in law enforcement, they often result in consent decrees where essentially the federal government has some control over how the local police department operates itself to ensure that it's not continuing to, have the same civil rights violations that caused the issue in the first place. I mean, is that something that's possible as a result of this?
Yes, and I think that's why the sheriff that's what the sheriff and others are most afraid of, because then they do get to live under, this federal oversight on them into these issues, and they definitely don't want that. I wouldn't be surprised to see, a big problem according to LASD is they don't have enough money or resources. I wouldn't be surprised now to see the county rush in and just triple their staffing to clear the backlog just so they can get this off their back as part of some settlement or something. We'll have to see how it plays out, but yes, the consent decree is a powerful tool that the federal government has in its arsenal that typically, not always, but typically private plaintiffs like us can't really get. So.
Right. Yeah. And so from your point of view, while the claims are very similar to what you're doing on the private side, the consequences for the Los Angeles Sheriff's Department could be much more severe and much more replicatable, I guess, across the country. Certainly you guys can continue to file lawsuits, but the Second Amendment Foundation or any other gun rights group, even if you're acting in a coalition with one another, you have far more limited resources to make these kind of cases than the Department of Justice does, right?
That's totally correct. And there's also, like it or not, I think we have some great lawyers. I think I do all right, but we just do not have the gravitas of the federal government. That matters, like it or not, that's just the reality. We just saw, I know it's not what we're discussing today, but we just saw the Supreme Court grant cert in a case. And a big reason why was because the federal government came in and asked them to. So that is just the reality. So that's why we're happy to have this help.
Yeah, and we might touch on that case at the end, just because you're here and it just happened. So we might just have you give a little bit of a preview of what you expect to happen in that Supreme Court case. But focusing back on the DOJ lawsuit, what are some of the claims? I got here, let's get an idea of exactly what the problems. You've mentioned a number of times that, some of these application processing timelines can reach out to 2 years, or even, I think the DOJ said sometimes even longer, nearly 3 years for some of these people who've applied, according to the DOJ's filing in this case. But just to give a scope of it, I'll give you a quote from the complaint. You can maybe tell us a little more about the situation out there in LA County. But quote, the complaint from DOJ reads, between January 2024 and March 2025, defendants received 3,982 applications for new concealed carry licenses. Of these, they approved exactly 2, a mere 0.05% approval rate that cannot be explained by legitimate disqualifying factors alone. This is not bureaucratic inefficiency. It is systemic obstruction of constitutional rights. Now, that stat is maybe a little bit confusing, but I think what they're saying, and correct me if I'm wrong, is that, during that 15-month period or so, LA County Sheriff's Department took in almost 4,000 applications from people. And of those 4,000, so not they may have been issuing other permits during that time from previous applicants, but of the 4,000 in that 15-month period, only 2 actually got approved by the end of March 2025. They're essentially claiming that they're saying, going above and beyond and saying the reason for that is not just that the department is bad at processing applications. It's more than that, right? They're saying this is on purpose.
Yeah. So, and to be clear, that is exactly what it is, what you mentioned about the timeline. So what that proves is, as we've always argued, they take over a year to issue permits. So in that time span from 2024 to March 2025, they were only issuing the 2023 permits that were before that window of time, because they take 14 or 15 months at best to issue these permits. So it makes sense that only 2, if any, were issued from people who had applied in 2024 or later. And I expect right now, in fall of 2025, we're probably going to start seeing more of those 2024s finally get approved. But yeah, so Steve's argument during our litigation they've never really denied the wait times because they can't, but their argument's basically like, well, it's not malice. We're doing our best. We don't have resources. We got this huge surge from Bruin, excuse. And while that may have been sufficient for us in the first year, remember, we waited about a year after Bruin before filing this lawsuit. We first sent a letter to the Attorney General in summer 2023 saying, hey, California has this time limit in state law. Are you going to enforce it? Because California has a 120-day time limit. It used to be 90 days.
Yeah, that's the other aspect too. Yeah. This is all actually illegal under California law.
Yeah, even separate from the whole Second Amendment, there's actually a California law setting a time limit, but the Attorney General did nothing to enforce it. So we had to bring a suit in the fall of 2023, almost 2 years ago, on this case. So we gave them a year to get their house in order. We were clear in our letters, hey, we understand Bruin created this surge, get things going. But now it's been 3 years. So whatever resources, I get that there's resource shortages. I understand California's weird in that we don't issue at the state level. We issue county and sheriff. So every sheriff has to handle this. But at the same time, I find it hard to believe that if voter registration were taking 2 years, the county wouldn't do everything it could to get resources in to get people registered to vote. So if you're going to insist on a permit requirement, particularly one as onerous as California's, you should be able to process it. And if you can't, that's not really our problem. That should be the government's problem. That's our argument anyway. Yeah.
Right. And just to give some more context from the DOJ complaint on, some numbers here, where they're again claiming that this is a coordinated effort by the department to nullify, essentially through bureaucratic obstruction, something that they couldn't do through law anymore because of the Supreme Court ruling. They're basically just saying that county doesn't want to issue permits, but now they have to. So instead, they're slow walking them. But here's the quote from the complaint. It says, defendants force applicants to wait an average of 281 days over 9 months just to begin processing their applications, with some waiting as long as 1,030 days, nearly 3 years. The median delay is 372 days. These delays far exceed California's own statutory requirement that licensing authorities provide initial determinations within 90 days, demonstrating defendants' flagrant disregard for both state and law and constitutional obligations. So, they're saying, I think, and hopefully you can walk us through what the process is actually like in LA County, because you have a concealed carry license there. You're currently waiting on a renewal, is my understanding.
Yes.
But one of the things that's a big controversy in this is the way that they go about doing the applications, which is not something we've seen this in other places, including Washington, D.C., for my own carry permit in Washington, D.C. But this has been an issue in places like Philadelphia, for instance. Over there's been litigation over this in Philadelphia, Pennsylvania. But one tactic that you'll commonly see is they require you to, and I believe this is happening in Los Angeles, but fill us in on it, but they require you to not just fill out an application and send it in when you're done, but you have to make an appointment to officially apply. So, and one of the things that's become an issue is that a lot of those appointment times in LA are potentially even a year out from when you first inquire about applying. So you could have all of the training that you need to obtain the license. You could fill out the application ahead of time, but you can't turn it in until you make this appointment and the appointments are not available for a very long time. Is that, can you give us a little more detail on how it works?
That's more how LAPD works, and they've gotten some, but LASD works in a similar way. They do treat it as applied when you send it in. However, before anything at all happens, you have to have an interview, an in-person interview by California law. So a lot of this stuff is due to California law, but although other counties have managed to be on time despite that. So you'll apply, you'll send in your application with your $30 fee or whatever, and then eventually you'll get a notice to schedule an interview. And those interviews have typically been about a year after people apply right now. So that's the very first interview. After your first interview, you are instructed to go do a live scan. I don't know if that exists in other states, but in California, it's basically a digital fingerprint thing. And you pay $100 for that as well. And then the DOJ does a background check. But at the same time, the DOJ is doing a background check, the LASD has to do, they have to check your personal references. They have to do all sorts of little internal investigations that state law requires. I don't remember if they still check our social media, but it's this list of things they search up about you that they ask you about and all that. And assuming everything goes well, assuming you get approved and your live scan comes back clean, then you get the notice to proceed to training. You do your 16-hour, 2-day training course if you're a first-timer, the shooting qualification, and then sometime after that, they will schedule you to come in and pick up your permit. They won't mail it to you. You have to actually schedule another time to come back and do it. So this whole process nowadays takes about 18 months, 14 to 18 months. It used to take 2 years. And it's very drawn out and very painful, I think, on purpose by state law. But despite the state law, despite all these requirements, counties like Riverside get it done in 2 or 3 months. You'll get your interview within a week. They'll tell you to take your training and do your live scan, and it gets done rapidly. LA's dragging it out, whether it's on purpose or because the county refuses to provide them resources. In our opinion, it doesn't really matter. They should have to speed this up. Yeah.
And you are personally going through this renewal process right now. What's that been like?
Right. So California has a 2-year renewal timeline on CCWs. Most states are 4 or 5 years. And there's actually a pending bill in the legislature right now supported by the San Diego County and Orange County sheriffs to extend our permit timeline to 4 years. But because it's 2 years, so LASD is not only processing all these first-time people, but also these renewals. And the earliest you're allowed to apply for renewal is 90 days before your expiration. In recent months, everyone who applies, even on time, I was 10 days late because I was in Greece, but I applied 80 days before the expiration and did my training early. Everyone who's done this has their permit lapse for a time period. So mine expired September 27th, even though my training and everything has been complete since mid-August. I've just been waiting for them to call me to have me come in and get the renewal. They do a telephonic interview for renewals, and then you have to schedule a time to come in and get it. And from what I've heard from other people, not only does it take a few weeks after your expiration to actually get the call from them, but then they ask you to reserve an appointment to come pick up, and even that's usually at least 30 days out. So now we have permits lapsing, and technically I have no legal right to carry in California right now. I have no legal avenue, I should say, because they don't honor the permits of any other state, no constitutional carry, and you can only get a permit from your county or city of residence. So this is my only permit that I can get. This is the only way I can legally carry. And right now I have no right to carry. If I were a little more foolish, I would call up the police and say, I'm going to be at Starbucks. I'm illegally carrying. Come and arrest me. And I can make a great case out of it. But I have a family and I can't risk that financial harm, But it would be, if happened, if somebody got arrested committing no other crime except they were carrying on an expired permit and they had applied and it's just been delayed, that would be a dream case. I hope that does happen, because I think that would be an excellent way to litigate this issue. So
yes, well, nobody wants to be the test case.
Somebody in Florida did on open carry, if you recall. That's how they got their open carry. He went out and was holding a sign basically saying, announcing what he was doing. And he won, but that was the happiest ending possible.
I guess I should say it takes a very special kind of person who will volunteer to be a test case. Usually you don't want to have to put up with the legal headaches that go along with that, especially when you could lose and go to jail. And you could lose in the intermediate, and maybe you eventually win, but it's not for years.
And
later.
if I knowingly break the law, I could be disbarred. It would ruin my career. So there's all that.
There's a lot of risk, even when you're in the right on these sorts of things. But getting to the sheriff's department and their claims, right? Because they did have a long response to this they sent us. after the case was filed. And they mostly I would characterize it as them disputing the overall message of the lawsuit rather than the specific details of it. They gave, we read some of the DOJ's statistics. I don't think they really disputed any of those statistics, but they gave some of their own to kind of paint a little bit of a different picture of what's going on. For instance, they're claiming essentially that they are issuing concealed carry permits and that they're actually issuing them at a much faster rate than they used to. From their department spokesperson, they said, "But it is important to clarify that the LASD's CCW unit has been issuing permits at a significantly increased rate, contrary to the statistics and information cited by the Department of Justice in its complaint." And then they gave their own stats here, where they said, despite significant staffing shortages, we have successfully approved more than 19,000 CCW applications since 2020. Year to date in 2025, we have issued more than 5,000 CCW permits, including 2,722 new applications. So that would, the new applications part would imply that they've issued, unless, and they didn't say the DOJ was wrong in its statistics, but that would imply that they've issued about 2,720 applications since March, I guess, if you're reading between the lines of these two dueling claims. So they do seem to have been ramping up how fast they're issuing these. Although I guess before we move on into some of the other claims they're making, or this other statements they gave us, I guess I would like to, using that number, 19, let's say take the bigger number, 19,000 permits since 2020, over the last 5 years. There's nearly 10 million people who live in Los Angeles County. Now, I think you mentioned earlier that LA Sheriff's Department is not responsible for issuing permits to all 10 million or so people in the county, because the city is also included in there. It does its own processing, and there's a few other parts of the county that do its own processing. So that takes out a couple million people. But, 20,000 or 19,000 permits might sound like a lot at first, but when you consider how big the population is, it's really quite small. For instance, Virginia, where I live, actually is smaller than Los Angeles County. The entire state of Virginia has a smaller population. Another thing I don't think most people understand about like this part of the whole, that part of the country is massive. Like the population in LA is just incredible. All of Virginia is about, I think, 8.8 million people. But Virginia has last report from the state police, which is a little outdated. It's from 2019, had about 632,000 concealed carry permits in a state, out of a population of about 8 million. And we have some research on this from John Lott and Carlisle Moody. They did a paper in 2023, a study where they essentially, and I think they do this fairly regularly. Their last revision was January 2024, but they estimated essentially, they go around and try to figure out how many concealed carry permits have been issued in every state. And they claim that about the national rate is about 8.4% of American adults have permits. And then if you exclude more restrictive states like California and New York, they claim there's about 10.1% of all adults have permits. So in Virginia, they're claiming about 10%, just under 10% of adults in Virginia have permits. Obviously 19,000 is far below 10%. I mean, if 10% of everyone in Los Angeles County had permits, it would be more like 1 million.
Yeah.
And then, if you take out Los Angeles, say it's more like 6 million people, that'd be 600,000, more in line with the entire state of Virginia. So clearly, I think they're way off the average, or these are rough estimates, I would say. I wouldn't count on them as gospel. They give you some idea of what to expect. And in fact, I guess just one more, there was a report from 2022 in the wake of the Bruin decision, where Cal Matters, which is a nonprofit newsroom in California, estimated that Orange County, which is the next county over, right, in Los Angeles, I think.
Yeah.
Is that right?
Where Disneyland is and stuff.
Yes, and they have about 3 million residents, is my understanding. And in 2022, they had 65,000 permits.
Yeah,
so
they've always been better.
Area.
Yeah.
Yeah, just even in California, where there's a lot of limitations under state law, and this was even before. A lot of those permits were issued before Bruin happened, and California was forced to change its laws and loosen up the requirements for obtaining a permit, because Orange County is obviously a more conservative area and has
and California law has always been for years that counties get to kind of choose,
right.
what good cause meant. So the redder counties were basically shall issue, but the coastal like LA and San Francisco were definitely not. So
yeah. That gives you some idea, like 65,000 in the pre-Bruin era in another California county that's smaller. That compared to 20,000 in LA County, even if you're just taking the most conservative approach you can in terms of how many permits it should be issuing or would be in line with other areas, they seem to be well behind the ball on this, right? I mean, that's kind of the core of of these claims, right?
Yeah, I mean, it's been a constant issue with them. And now you're seeing, they mentioned the 5,000 number. First of all, those 2,700 that they have issued that are new are probably, again, from 2023 applicants. And second of all, it's showing that how much this renewal process is a problem, because almost half of these are renewals. And what that is it's that Bruin surge from 2022. These people are now coming back around for renewals. The people who got the first wave of the Bruin permits now need renewals, and those are getting delayed. So, we've urged the sheriff, hey, why don't you go tell the legislator about these issues, get them to extend the permit validity? Or as we've argued, we've told the sheriff, he's ignored us, but we've told him, you could issue a statement saying if you've applied for renewal, then you're good. You're safe as long as you applied before your deadline. And that's state law in places like Michigan and elsewhere. His excuse has been, well, I can't break state law, but he doesn't seem to care about breaking the state law on the time limit. So we don't think he should be able to pick and choose there, whatever benefits them. But, that's how it goes.
So additionally, and this is, by the way, the sheriff in Los Angeles County is named Luna, right?
Yeah. Sheriff Luna.
Sheriff Luna. And his office also had a couple of other reasons they gave. They didn't, again, I don't think they really dispute DOJ. They might dispute sort of the overall picture that DOJ is painting, but it seems to me the statement that they gave us does, in fact, say that they are having a hard time processing applications quickly. Now, they had reasons for this. They had, in fact, two specific reasons that the office gave us. One deals with how the actual system for processing permits, which they said, quote, when they're talking about when DOJ first started to investigate, they're saying that they were switching between two systems. And they said, quote, at the time, the department was in the early stages of transitioning from a manual paper-based application system, the concealed weapon tracking system used since 2005, to Permidium, which is a new online platform that streamlines application processing by allowing electronic submission of documents. The upgrade to Permidium, implemented in May 2023, was part of broader efforts to improve efficiency. But although they say they still use the old system, but eventually that they'll phase out that old paper-based system for this new digital system, although they didn't give it like a timeline, and it's not clear why it's taking more than 2 years to do that. But that was one part of the excuse. They said, well, we used to use a slower paper-based system. Now we're moving to this more efficient.
Some context on
system.
that. When we first sent them a letter before we sued them saying, hey, let's fix this or we're going to have to sue you, I got this Permidium excuse back then in mid-2023. So how long is this transition going to take here? They've been using this excuse of this transition of Permidium for 2.5 years now. Come on, let's move on, guys.
Yeah, it's a bit of an odd one there because, again, that's that kind of a theme here in a lot of what the sheriff's office is saying, because the other excuse that they gave was that the Bruin, which again, Bruin happened in June of 2022, so it's been more than 3 years. Bruin created this huge demand and a backlog, and that the previous sheriff, Sheriff Villanueva, Alex Villanueva, wasn't prepared, didn't take any measures to prepare for this influx. They said, quote, following the decision, a surge in applications significantly increased the volume of backlog cases. Since taking office, the sheriff has inherited a dysfunctional system that was not funded for staffing, but has taken proactive steps to reduce the backlog, improve the process, and establish a fair and balanced approach. When he assumed office in December 2022, the key date there, the backlog was approximately 10,000 applications. It has now been reduced to roughly 32,000. 13,000 have been unassigned and 1,900 are in the background process. I mean, they're claiming that they're making progress on this backlog, but again, this guy's been in office for 3 years. I mean, he's blaming his predecessor, who was out of office just after the Bruen decision was handed down. I don't know. What do you think? Is there any legitimacy to this claim?
No, because Sheriff Villanueva, first of all, he was the one that before Bruen did start issuing some permits. Like I got my permit before Bruen from Sheriff Villanueva because he opened it up just a little. LA used to issue to nobody, and he made it so that, okay, certain people, lawyers, certain people, if you work in security, you could get a permit. But to say that Sheriff Luna inherited a dysfunctional office. What he actually inherited was a pre-Bruen CCW office that was tiny because they issued to almost nobody. So of course there wasn't a lot of people there. Now maybe you could say in those 6 months or whatever, I guess Sheriff Villanueva should have staffed it up. Maybe, sure, we agree. But you're right. It's been 3 years now since then. At some point you gotta stop blaming your predecessor, especially when you're almost done with your first term here as sheriff. You're 75% of the way through and you're still blaming your predecessor for something that happened at the very end of his tenure. So I think that's a silly excuse. And again, that's why we gave Sheriff Luna around a year to get things in order, but nothing happened. So we sued,
Yeah. The other explanation that the sheriff's office offered to us is one that you've alluded to earlier, which is that, quote, currently only 13 personnel are assigned to this unfunded mandate, and the department continues to face a significant staffing crisis. The department has been working closely with the LA County Chief Executive Office to secure appropriate funding to address staffing concerns for the CCW unit. So they're also saying essentially the county is not providing them with enough money to effectively process these applications. What about that? Do you think?
I think I wouldn't be surprised if that's true. There is a possibility here that the CCW unit, the 13 people there, maybe even the sheriff do want to get this done, but they're just not getting the money. And that could square with reality because the county is extremely anti-Second Amendment. And I could see them, if the sheriff goes to them and says, hey, we need more staff. And they say, for what? And we say, so we can process CCWs quicker. They'll probably say, no, we're not going to do that until they're forced by a court, or in this case, the federal lawsuit. So it is probably true that, the county is purposefully not giving them the funding they need to get this done. Because like I said earlier, if this were some other issue, if it were voter registration or something they cared about, I'm sure resources would be quick to come down and the situation would be addressed immediately. Because all they really need, double or triple the staff for a time period to clear the backlog and then get this done. Now, the sheriff talks about unfunded mandates, and I would tell him, you should talk to your political allies in Sacramento because they can fix this. They could extend the permit validity. They can get rid of all these other requirements. They can make it like most other states where you just do your background check, maybe a training course, and you get your permit. So if he has a beef with that, that's not our fault. That's up to him in Sacramento to figure out, I think. So.
But you don't see it as a valid excuse for the delays that are.
No, this is a constitutional right. And if the government's saying that, we're just too busy, well, you're the ones requiring a permit. You could join the other 29 or so states and do constitutional carry. I know the sheriff can't, but I'm talking about the government as a whole here. They could make that choice. Because they've made the choice to require a permit, it's not on us, to deal with their excuses about being too busy or not having enough staff. You need to figure this out. This is a constitutional right. That's been our argument. So.
Okay. And so from this point, what should people watch for in this case? What's the next step in the suit that you guys have going, and then also in this federal suit now?
Right. So in CRPA versus LASD, it's been a minute since I've looked at the docket since I left my last job, but I believe it was set to go to trial in early 2026, the first couple months. So if no settlement happens, look for a trial then, or motions for summary judgment around then. So we'll get a ruling. As for the federal DOJ case, it's going to go one of two ways, I think. It's either going to go very quick because the county's going to wake up and say, let's get the feds off our back. Let's, give them everything they need to process these permits. That would be the quick resolution. If the county digs in, because it could go the other way. You could have, right now there's a lot of political heat, especially from Democrats on the Trump administration. So the county might go the other way and want to fight it and say, no, we don't like Trump. So we're going to go to the mat on this. And then it will drag out into a longer lawsuit, and we'll have to just keep track of what happens there. I don't know if they're going to need more discovery because they just did an investigation, but I'm hoping that because they're the federal government, they can push it along quicker than the over 2 years we've been litigating CRPA versus LASD to try and get some traction in the courts.
And I assume you'd like to see this repeated elsewhere too. Are there any other cases, similar cases that you guys have in other parts of California or other states that
we don't have another
DOJ
wait time? Right. We don't have another wait time. Well, we have wait times cases, I believe SAF does in Massachusetts and elsewhere. So we'd love to see that. But there's also other issues too. We just sued along with CRPA again, Santa Clara for $2,000 in fees. So that's the other side of the permit issues. LA takes too long, but Santa Clara charges a crazy amount of money, which LA's fees are expensive compared to everywhere else in the country. But for California, they're about average. So that's another issue DOJ could take up. But yeah, if they get a win here, I would hope to see them call up LAPD, Alameda County, Contra Costa County, these other places in California and in places like New York City and elsewhere that take over 6 months or longer to issue permits and say, hey, we're going to do the same thing to you unless you get your house in order quickly on this wait times issue. And we've seen them in DC. I know DC permits are suddenly moving very fast. So I know they have a lot more control there than they would here, but that's something we hope to see happen nationwide. Yeah.
Yes, it is. And then, so the Trump administration has been pretty consistent on this particular area, where they have reduced wait times in Washington, D.C. You can see it when you go look for those application appointments that they have sped a lot of that up since the second Trump administration has come into office. So this is an area where they have been fairly consistent, it seems. Moving just last bit here, since we mentioned it earlier, today, we're recording this on Friday, the Supreme Court has decided to grant cert in one of your cases, one of the Second Amendment Foundation's cases.
Correction, it's not a Second Amendment Foundation case. It's one we've supported, and it's one, I understand the confusion. We were heard together with that case in the Ninth Circuit in May v. Bonta. And we've supported cert in the case, but it's Alan Beck's case, great guy, and some other plaintiffs there. Yeah.
Yes,
but it's very close to our hearts.
Yeah, thank you for clarifying that because it's important.
I love taking credit for stuff.
Yes, and we'll have to have Alan on the show. We've had him on the show a number of times. But yeah, and you mentioned there that it was a combined case. So they're not taking that combined case. They're just taking
that was a choice. So we went up. Wolford is the Hawaii case, May v. Bonta, and Carolero v. Bonta are the SAF, CRPA, and then FPC had the Carolero case. And they all deal with the same issues, and they were heard together in the Ninth Circuit. But because our vampire rule, the Ninth Circuit reached this really weird ruling where they said the California vampire rule is not okay because it only requires a sign. But in Hawaii, theirs is okay because you could also ask for permission. Like if the owner said, yeah, come in, that's enough. So it's a really strange distinction. But because we didn't have that hook of the vampire rule, we decided instead, especially given the Supreme Court seemed to hate preliminary injunctions until now, we just said, you know what, we're going to go get a final judgment. We're going to go back down and then come back up. But we did file an amicus brief in support of Wolford's cert petition on the vampire rule. So we did not seek cert, and that's why we're back at the district court. And Alan, being smarter than us, is now at the Supreme Court.
And this is a case, can you explain, although as I mentioned on the news update, I think a lot more people understand what vampire rule means in the wake of the success of Sinners.
Sure.
But can you just get into what exactly the details of this case are?
Sure. So after Bruin, the states that were hostile to the right to carry, that's New York, California, Maryland, Hawaii, New Jersey, wanted to do anything they could to try and limit this new right to carry they had to honor. So the most nefarious, they banned carry in parks, bars, all sorts of places that we're currently litigating. But the most nefarious one, the one that really kills the right to carry, is this vampire rule. They call it a property default rule. And what that means is if you have a business that's open to the public, think a grocery store, restaurant, whatever it is, unless they post a sign or otherwise give you permission saying, you are welcome to come in here, people who carry with a CCW permit, you can't enter. So it's like Dracula, like Sinners, where vampires can't enter a place unless they're invited to come in. So that's how my buddy Rob Romano on Twitter of FPC came up with the term vampire rule, and then I used it everywhere because I loved it. So we're hoping that the Supreme Court uses the term too. We'll have to see.
And
but that's where it comes from.
That's essentially the opposite of how it's been done pretty much everywhere.
Yeah. So for all of, even up till now, but through all history in the United States, you have to post a sign saying no carries allowed. There is a slight exception in that back in the 18th century, there was laws saying if there was fenced off enclosed property, not open to the public,
right,
but like this is your private plantation, whatever else, then you'd have to get permission. It was usually to do with hunting. So you'd have to get permission to bring a gun on because they were worried about poaching. But it's always been when it comes to businesses that are open to the public, held open, not enclosed property, that you have to put up a sign saying you don't want people to carry arms, not that you're inviting them, that you have to post it if you want to invite them in. So, yeah.
All right. Well, we will have to have Alan on, I guess, to talk about that.
Yeah, you absolutely should. And it's a very big deal. You know, I think we were discussing before the show, in the one sense, it is like the easiest, least they could possibly do. It's such a simple issue. But at the same time, they have been so hesitant to grant cert that we will take what we can get. So we're thrilled for Alan, and we look forward to doing an amicus brief in his support again. Yeah.
All right, great. Well, we'll have to have him on soon and discuss the details and what his strategy is for litigating the Supreme Court. But I'm sure that's an exciting day for any lawyer who gets to do that. But yeah, that's all we've got for this week. If people want to follow the Second Amendment Foundation and your work with them, where can they do that?
Sure. So you can follow the Second Amendment Foundation at 2AFDN, I think is the Twitter handle. So the number 2AFDN. You can follow me at Moros Kostas, MOROS on Twitter also. And at SAF.org for the website and all that. You can find all our other social media.
Well, thank you so much for being with us and giving us an update on this. It's one of a kind DOJ case. And we will have to have you back on when we get some more developments on this front.
Anytime, Stephen. Thanks for having me.
Absolutely. That's all we've got for you guys this week. We will see you again real soon.
No, the devil's got no